related to various facets of the impeachment proceedings against the first petitioner, in this case, before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenge the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle in law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gachagua Peter Munya versus Dixon Mwenda Githinji. And I have stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classic case of Gachagua Peter Munya, which I have said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also cited the case, the court in Wilson, Kaberia, and Kunja. You'll find them in our ruling. Having considered those, then what we then looked at are the elements for granting a conservative order. These are, we are giving them to you in point form, but we have discussed them in detail in our ruling, which we shall give. For the sake of completeness of the record, we have dealt with the merit of the application and whether conservative orders should issue, whether prima facie case has been established. We take the view that the same has been established. The applications raise constitutional issues that require further judicial interrogation. Whether any prejudice will be suffered by the applicants. No prejudice if the applications are not granted at this stage. The process is a lawful constitutional process, and the Senate will conduct a trial where all the issues being raised before the court will be raised and determined. At the moment, we are being called upon to anticipate the outcome of a process yet to be completed. The application at this stage is premature and anticipatory. Should the petitioner not succeed, the petitioner still have an opportunity to approach the court after the process. The applications are not without remedy. On the issue that has been raised that as soon as the Senate impeaches the DP, if at all that happens, that the DP immediately ceases holding office and he cannot reclaim office, we take the view that every office holder can only assume office legally and constitutionally. The assumption of office cannot oust the court's jurisdiction. The court has unfettered jurisdiction to check on the constitutionality of the process at whatever stage. Whether the grant or denial of the conservative order will enhance the constitutional values and objectives in the Bill of Rights, we find that exercising restraint at this stage will enhance and allow independent institutions of government to function unhindered and in their fullness, except in the clearest of cases. It is our view that this is not one such case where intervention is automatic. The issues raised by the parties will require to be interrogated. We therefore find that the enhancement of the constitutional principle of separation of powers will be best served by declining the application at this point. Whether the petition will be rendered nugatory, we find and hold that it will not. The petitions challenging the process of impeachment, the petitions are challenging the process of impeachment. The substratum of the petitions will not be lost. The court is still able to grant a remedy even after the process is conducted, even after the process is concluded, and as such, the court will not be acting in vain. On public interest, we find that the public interest tilts in favor of allowing the constitutional process to proceed unhindered. Disposition, therefore, deriving from the foregoing, the following final orders do issue. The consolidated applications are hereby disallowed, caused to abide the outcome of the main petitions. That is the ruling of the court.
As we wait for the ruling on behalf of my colleagues, I know senior council members would have wished to do this, but I have the power to thank your lordships for the interest and time that you've taken, my lord, knowing that we met here yesterday at around 9. Lord, I have no doubt that you might not have had some good lessons. But we want to thank you for allowing us to have argued before you yesterday and before you delivered of this ruling within the time, my lord. We will wish the Deputy President all the best, my lord, for the Senate. I thank you, Lord.
Thank you.
In the leadership on behalf of the first petitioner, this is Jomo for calling me for Mr. Parliament Senior Council for the first petitioner. Noting that the proceedings before the Senate are virtually now commenced at 9 a.m. We don't know the outcome of that particular process, but nevertheless, would require that we appear before your lordships as soon as practically possible, and preferably, if possible, on the 15th of October this year, so that we can take directions for hearing of the petitions that are now pending.
18th of October is which day?
On Friday, this coming Friday. Senate proceedings, my lords, and your leadership will conclude tomorrow. We don't know what time, but it will be at night. and it will be necessary that to protect the rights of the past petition, that we appear before you to take directions for hearing of the petitions. Again, my lords and your leadership, because of the unknown outcome of that particular process, it might be necessary for the past petitioner to amend the petition depending on the outcome again. So at this point, at this juncture in time, we also pray for leave of the court that if necessary we can amend our petition before we take the directions of filing. If leave is granted, my lords, you can comply with the amendments process as soon as possible. If you grant us time, we'll be happy to appear before you on Friday so that this subject matter is not just. Thank you.
Your Lordship, my name is Gachagua Ruto for the 7th petition. Mine is just
Mr. Wathuta?
yes, Judge.
Yes.
It's just more or less a housekeeping request. Firstly, maybe in the course of the day we can get an indication when we can lay our hearts on the ruling for our review. Secondly, after tomorrow's Senate proceedings, and as indicated in the ruling that remedies can be sought thereafter, and noting the challenges that we had last week in lodging documents at the last minute, we are seeking for permission, if need be, to lodge documents manually, just in case the CTS system will not be accessible like it was last week. And that's all, my Lord, the lady.
On behalf of the men, the communities from Park, the works of the city, the men, the petition thank you for what transpires at the Senate.
Mr. Lempa,
Yes,
what are you saying?
I am saying, my Lord, that we be seeking leave to amend the petition depending on what transpires at the Senate, and will also associate ourselves with the submissions of Mr. because of the challenges we experienced last week from the CTS. If necessary, the scheme allows us to launch our documents physically.
My lords and my lady, my name is Simon Mburu for the 8th petitioner. I associate myself with the submissions of the past 7 and the 9 petitioners, and also wish to seek leave to amend our petition, as the courts have already appreciated the manner in which this matter is mutating, and depending on the outcome of the Senate tomorrow, would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court. That is all.
We don't want to close out anybody. Is there any person with further comments? Then we will consult on these applications.
My Lord, for the respondent, I thought you are referring to
Okay.
petitioners first.
All right.
For the response, my Lord, on the applications that have been made by my learned colleagues on leave to amend, my Lord, you shall note that there's been no disclosure on the would-be intended amendments that would be sought, my Lord, to be incorporated if leave were to be granted. My Lord, we want to avoid a situation where we will be faced with a totally new petition disguised, my Lord, as an amendment to the petitions before you. In our humble view, my Lord, there's a very good reason to request that if there's any party, my Lord, who will wish to file an amended pleading, my Lord, that they seek that leave formally by way of an application. So that then, my Lord, the respondents will be given an opportunity to appreciate the nature of the would-be amendments and respond accordingly, my Lord. To seek leave, my Lord, in the nature that have been done now, an open blanket leave would, my Lord, be totally unfair to the respondent, as we do not know, my Lord, how that leave would be utilized. My Lord, we are therefore vehemently opposed to that application of leave to blanketly amend the petition. My Lord, there are rules that govern amendment of pleadings, and before you grant that leave, my Lord, you must be certified that that threshold has been met. None has been demonstrated, my Lord, by the blanket requests that have been made by our learned colleagues. My Lord, on the other request that we mentioned this matter on Friday, my Lord, I will refer you to the ruling that you delivered this morning, where you've been expressed, my Lord, that this court would provide a remedy at whatever time is moved appropriately. You've also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have about 23 matters related to the consolidated petitions before you. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mulima, if we were to know what we are going to say, we are going to limit the time, because the applicants have not used the amount of time you have used in response.
Thank you, my Lord. My Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue. And that, my Lord, we will be available to come back before you any other date, my Lord, next week, for a mention. I should note, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you reply. I thank you.
Thank you.
Lord, and your leadership, will be just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, we don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents will then have a chance to respond. So that in case an amended petition, your Lordship, is filed, the respondents will not be prejudiced in any way because they will have an opportunity to respond to the amended petition. So that even if there's a change of the prayers or anything in the petition, then they will have an opportunity to respond to anything that could be introduced in the amended petition, so that there is no harm in allowing that particular prayer. And we have had an experience in this, my Lord, in a matter that was very true. When parties sought to amend a petition, Mr. Milimo's side post the amended petition on the basis that leave had not been granted. So to avoid all that, and noting that this is a matter that has very strict time constraints, we would think that it would be prudent that this court allow at this time that you can file an amended petition. On the second issue, the mention of the outcome is two-way. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention on Friday will therefore help in updating this honorable court on the outcome of that particular process before the Senate, so that we either seek direction for hearing of the petition or we update the court as we are hoping that the charges will be dropped, that these petitions have then been overtaken by them so that they don't continue holding the shares of the court. So that it is important that we don't spend a lot of time in getting directions for these petitions that are pending before the court. That is why the mention is urgently needed so that we can address that issue conclusively. Thank you.
Yesterday when we were online, I heard Mr. Milimo saying that the parties are bound by their dealings. Therefore, it cannot be had this morning to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of the bill. And therefore, the submissions by Mr. Milimo are speculative that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. I've had Mr. Milimo submit that advocates who are not present they have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding free for certain reasons. Therefore, no party will be prejudiced by any direction that has been given by this court. In conclusion, Mr. Milimo's opposition to the election of our petition is just universal in this matter.
What did you say? That one. It's just. What did you say?
It's universal.
Fully?
Universal.
What's the spelling? Filibustering.
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that word?
To stall the process.
Yes.
That's an easier way of saying it. Yes.
Delaying something without necessarily breaking the rules, what filibustering. I understand it's a definition of filibustering, but I had looked at it before deciding to. So that it's an opposition for opposition's sake. Nobody intends to abuse the process of this by amending. We'll add a paragraph or thereabout, and he knows what is like. Parties have submitted depending on what will happen in the Senate. They even need to amend their petition. So they have that does not amount to an abuse of process. That's all.
Thank you. Do you have any parties online who want to comment on this matter?
My Lord, if I may just make one remark, and this one is for the benefit of Mr. Milimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a recent ruling, which you'll be getting a copy of today, Mr. Milimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process necessitates constant updating and amendments. So this is not one of those cases where facts exist and they don't change. They change every day. So that by the end of today, by the end of tomorrow, the facts will be totally different. So let us leave that room open, at least up to the conclusion of the Senate proceedings. Thank you, Madam.
My Lord, for the record, my then colleague will confirm, I was not in Kerugoya. I don't know whether I'm a prominent visitor. You must withdraw. I was not in Kerugoya.
Sorry, my Lord, Mr. Nyamode, his senior is the one who is leading the delegation.
Thank you.
My Lord, my lady, on the part, my name is Ukola, for the third, fourth, and seventh respondents. On our part, we thank you for your ruling this morning, and we thank you for allowing the fourth respondent to proceed with the constitutional process before it. On the applications made by counsel for the petitioners, we shall abide by the directions of the Senate.
Thank you. Do you have any parties, counsel online, who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend petitions except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
Nimekuwa Citizen duka nikapata wako na ofa ya okoa wiki hapo kwetu. For only 442 shillings nimeweza kupata yawa mkate at only 79 shillings na masiwa je at 45 bob. Na sababu wa Kenya tunapenda ugali. Nimepata unga at only 89 shillings. Na mchele ya pisori je hiyo pia iko at 189 shillings a kg. Hizi sote ni less than 500 bob. Imagine nimelipa tu 442 shillings nikaweza kusave 88 shillings.